All right, I wanted to give you some tips for the workshop that's coming up about how to deal with exhibits. And when we're thinking about exhibits, really there are three ways to think about exhibits and prepare for them. First, you've got to have an idea of what the technical steps are. And what I mean by that is really what the dance steps are from the time that you grab that piece of paper until you can move it into evidence, and want to walk you through each one of those steps. Second, I want to talk to you about what we'll talk about as the legal foundation. I mean, that's the place where we as lawyers live. We're worried about what are the magic words that we need to say over the top of the document to make sure that we can get them into evidence and get the maximum use out of them. Ideally, what we want is not only for the legal foundation is to get them into evidence, but presumably if we can get them back with the jury, then we want to do what we need to do legally to get them back with the jury. And then finally, I want to give you some suggestions about how to use them persuasively, that getting them into evidence is just half the battle. For the jury, what they want you to do is to show them to them and to have them see what it is that's important for them to see. None of this, well, we'll wait for you to go ahead and think about it later. If you've gone through all of this trouble to get it in, then the idea is how can you display it to them in the course of your examinations so that they can get the maximum benefit about what it is that the exhibit shows. So let's start with the technical foundation and the dance steps that you need. Now, the importance of this is that you show yourself as being someone who is in control of the courtroom. And in fact, it gives you a way to increase the drama of what it is that you're doing if you handle the exhibit with some alacrity, some speed, and with some precision. So let's go through each one of the steps, and then I'll give you an example with a couple of specific exhibits just to get you to see what it might look like. So what are the different steps for picking up the exhibit and getting it into evidence? At the point where you pick up the exhibit, you first need to know that what you're having in your hand is going to be one of two things. Either, and this is in most commercial cases, and it will be the way that we will assume you'll work in BMI versus Minicom, is that what you have in your hand is a document that's already been pre-marked for identification and given an exhibit number. How does that come about? Well, pre-trial, you're in with the judge, and the judge is saying, I don't want to take the time to have you go over and give it to the court reporter and have the court reporter mark it with an identification number, and then have the document put into evidence, and then have the identification numbers stricken from it, and then a new exhibit number put on it. We're not going through that. What we're going to do is we're going to pre-mark the exhibits. We're going to pre-mark them in a way so I will know what you're talking about, your opponent will know what you're talking about, and that will give us a lot more speed as we go through it. Now notice that then when you pick up the document, what you're saying is, I have in my hand a document that's been marked for identification, and you give it that number, and the announcement is for the court to, in a sense, go to the trial bundle or to go to their notebook and look in it and see what it is that you're attempting to do. If you're dealing in an electronic setting, then of course the court can look at that and know what it is that's going on the screen and be prepared if they want to hit the kill switch to make sure that it doesn't get shown because the court has some problems with it. So you say, I have in my hand a document I've marked for identification as Exhibit 1. And then often what you also do is you say, what appears to be the price list for BMI, something that gives it also beyond that exhibit number, something that gives it an identification in the case. Now note how it changes, however, if what you have is no pre-marking. And recognize for those of you that are future prosecutors and public defenders that the court may in fact not have a pre-marking routine. Then what you do is, I have in my hand a document I would like to have marked for identification, and handing it to the court reporter, could I have the document please marked? Then we're giving it that pre-identification, and anything that's referred to in the courtroom needs an identification number and identification marking. If, for example, this exhibit is not allowed into evidence, despite the fact that you have laid a proper legal foundation, then the document's identification number for the appellate record will identify it for the court to then review that evidentiary decision down the road. So let's just assume for our purposes that the document has been pre-marked for identification. So your first step in your dance is I have what has been pre-marked for identification as Exhibit 15. The second step is to, in some ways, let the opposing counsel take a quick review of what it is that you've done, what you have in your hand. Now notice that the opposing counsel is not just being a jerk if they interrupt you as you're heading out toward the witness by saying, "Counsel, can I take a look at it?" You remember that the federal rules of evidence provide that under 612, anything that's shown a witness for the purposes of refreshing their recollection is something that needs to be produced to the other side. And so when you're heading up there, the opposing counsel has every right to say, "Can I see what you're about to show to the opposing counsel?" So to take the opposing counsel out of the picture, one way to deal with this second dance step is just to say, showing it to opposing counsel. Now some lawyers don't like to say it out loud, they just like to go over and hand it to them. There is in fact a little bit of a debate about whether or not that gives too much credit to your opposing counsel to in fact say it, showing it to opposing counsel. But in any event, I like to do it because if the court is worried about whether this is something opposing counsel has seen, remember in our pretrial conference, if we're all on the same page, this shouldn't be a problem, but you want to go ahead and say, I would say to the court, showing it to opposing counsel. Notice also that opposing counsel should look at the document and examine to see if it's in its good condition, because if it has been marked on or highlighted, as we want to do as young lawyers, we take a yellow highlighter and highlight the key part. If that's on there before the document has been admitted into evidence, then of course it's not in its original condition. And so opposing counsel can also check the document to ensure that its condition is the way it's supposed to be. And if it's not, can object on that basis. Number 3 is the step of asking to approach the witness. Now, why go through the politeness of doing that? Your Honor, may I approach the witness? That's what you're going to say, and you want to do that because you do not know, or you may not know, what the bailiff has been told. And frankly, in criminal courts, and certainly this is a serious issue in Georgia, if you approach the bench without permission, the bailiff may tackle you. So what you need to know is that by asking, may I approach, you are in a sense giving the court notice that you're heading in their direction. Now, a court might say to you, counsel, you may move freely about the courtroom. And if you've been given that instruction, then asking to approach is not something that you need to do. But I like it as part of my dance step routine, at least at the beginning, so that I can make sure that I show the jury I'm respecting the court and make sure that I don't get tackled by the bailiff. So the third step is, Your Honor, may I approach the witness? Now the fourth step is to hand the exhibit to the witness. And what you're doing here is you're handing it and naming it. I hand what's been marked for identification as Exhibit 16 and asking the witness, do you recognize Exhibit 16? And can you tell us generally what it is? The idea here is that what you want to do is to establish that the witness has the foundation to be able to testify about the document. Now, if the documents have been pre-admitted, then this step is not necessary and in fact creates a really nice little wrinkle. But again, in traditional courtroom settings, if the document hasn't been something this witness has seen, you don't lay that foundation, your opposing counsel can object on a lack of foundation basis. So you take care of that by saying, I hand you what's been marked for identification as Exhibit 1. Do you recognize it? Yes, this is the price list of BMI. And so generally, what kind of document it is? It's the price list that BMI has that it sends out to its customers. Now there is then the foundation and leads to the next step. Now the next step in the foundation is the legal words. And what the court likes and is assisted by is the ability to have right next to the place where they're going to rule the key components of the legal foundation for the exhibit. Now let me give you a little tip here. The best way to handle this, if you've looked at this document and you've seen it and you've figured out what the magic words are going to be, that you go to the rule and you take out God's gift to trial lawyers, which is Post-its, little yellow Post-its, and you take the Post-it and you write out the elements of the magic words from that rule that allow you to go ahead and get that exhibit into evidence, and you put it on the document. And so if you're walking up with that Post-it and you take that off and you read that, you are guaranteed to make sure you have the precision that you need to lay the foundation for a business record or whatever it is. My suggestion to you is then that what you do is you prepare a trial notebook. And when you have the exhibits that you're going to use for Virginia Young in your exhibit book, that you have those exhibits listed with the yellow post-its that describe the legal foundation for each one of the exhibits that you're going to use. When you reach it and grab it, I have in my hand, show it to opposing counsel, may I approach, handing you what's been marked for identification as Exhibit 1. You've got your yellow post-it in your hand. Do you recognize it? Yes, I do. Now, is this document a document that's prepared by a person with knowledge at or near the time that it's recording the events? And is it done as a part of the business record keeping of the business and as a part of a regularly conducted business activity? And is it the policy of the business to keep these records? Yes, 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 yes. You ask those questions. Notice you can ask them in a leading format because these are preliminary questions for a legal ruling. And when you get those answers, then you may move the document into evidence. Notice here, don't be tentative at all about the foundation in which you're moving it in. You have the legal right now to have this document into evidence, and so I move Exhibit 1 into evidence. I offer Exhibit 1 into evidence. Watch for the kind of openness to or pleading with the court that can creep into your voice here. Not, I would like to at this time with the court's permission. Now, the reason I recommend against that kind of phrasing, at this time, with the court's permission, I would like to, is that the court might say, oh, counsel, do we have to? Can't we just move all the documents in at the end of your case, and then the jury can look at which ones they want to look at? And of course, your position is, no, I want them in right now. I've gone through this whole problem. I want the document in. And so I offer Exhibit 1 into evidence. I move Exhibit 1 into evidence is a more assertive way of trying to ensure that you control the order and the mode of proof, even though the court has some discretion in this matter. And then, of course, the last piece of it is to use it. And let me just say that when you're using with a visual display, electronically visual displays of your documents, it's very easy for you at this point just to simply say, I would like the operator to give slide 15 or slide 2, which is Exhibit 1, all right? And the slide number, as you remember, is different from the exhibit number. You ask for the slide number, and you do not need to lay a separate foundation for the exhibit as long as that exhibit is, as an officer of the court, it should be exactly in the same condition that it was in when you had your pretrial conference. Now, if you are going to annotate it, or if you're going to do a call out of the document, well, you should state that that's something that's going to come when you do the call out. But at this point, your steps are these as follows. Your Honor, I move Exhibit 1 into evidence. For the purposes of showing it to the jury, could I have slide 2? Thank you. And then what you need to do is you need to decide where's the witness going to stand in relationship to that exhibit, and how is the exhibit going to be used? But we'll say a few words more about that when we get to the persuasive use of the exhibit in just a second. So a quick review. I know we've gone fast here, but you can see how quickly you could do this if you can get this into your lexicon, into your habit or mantra of dealing with an exhibit. The steps are as follows. I have in my hand a document marked for identification as Exhibit 1. Showing it to opposing counsel. Counsel, Your Honor, may I approach? I hand you what's been marked for identification as Exhibit 1. Appears to be the price list. Do you recognize this? Yes, it does. Yes, I do. How do you recognize it? Well, this is the price list that I send out to all of our customers. And is this containing the operative facts that condition the business that BMI will do with its customers? Well, I don't know what you mean about operative facts. Well, are there terms in it, legal terms, which condition the way that you'll do business? Well, yes, there are. I move Exhibit 1 into evidence. For purposes of publishing Exhibit 1 to the jury, I'd like slide 2 to be shown to the jury at this time. Now, those magic words you see were not the business record. Those magic words are a legally operative fact The document presumably has this condition in it by which it will not do business without the written orders, and therefore there's an argument that it comes in because the document has independent legal significance. We'll return to that issue when we talk about the legal foundation in just a minute. But in any event, there needs to be some magic words cast over the document. That's the place you cast it, you move it, and then you show it. So let's talk about magic words. And first of all, let me tell you that in BMI versus Minicom, you are not given an opportunity to do what you would be given in any automobile accident case, and likely you would be given in any kind of a crime scene case, where what you need to do is you need to show to the jury a diagram or some kind of a layout of the scene of what it is that you're talking about. The legal foundation for diagrams, illustrative exhibits, are very simple. And the illustrative exhibit is, will Exhibit A assist you in explaining your testimony to the jury? Exhibits that are illustrative in the way of diagrams and intersections are then helpful to the jury as long as it assists, the witness is asked whether it assists, and as long as it's not unfair, and as long as what happens is that it doesn't distort in some fundamentally unfair way. Illustrative exhibits do not need to be to scale. And in fact, illustrative exhibits could be just a set of bullet lists that help us understand the testimony. They can be prepared by the witness themselves, like an expert witness who lays out a chart or a graph to help explain the calculations that he made. Or it can be a set of bullet points of a doctor who is testifying as to the things that were important in his diagnosis. What you have then is you have an ability to work with a witness to prepare an illustrative exhibit for the purposes of helping teach the jury what this witness has to say. And the foundation is that the exhibit needs to be illustrative, helpful, and it cannot be misleading. Now notice that in a demonstrative exhibit, in an exhibit where you are going to mark on it and show right where the point of the collision was, or you're going to demonstrate something that's at issue in the case, a little further foundation needs to be laid. When you have that kind of an exhibit, what you're doing is you have to ask when the exhibit is so marked, whether or not fairly and accurately shows the relevant point of the collision. And the fair and accurate language is the language then that needs to be additionally added as a foundational element for a demonstrative exhibit. Same about pictures, same about anything that presumably shows a view that folks have, and your magic words over that document are fair and accurate. Now I put these up together because I just want to show you that for the most part, illustrative exhibits are not going out with the jury. They're mainly teaching aids. They stay up for as long as the witness is up. A demonstrative exhibit, though, might go with the permission of the court out to the jury. And since that's the court's discretion, the court needs a little more of a foundation to be able to get it out. Because there is not a lot of clarity in many courts' minds between the difference between illustrative exhibits and demonstrative exhibits. Often, lawyers will try to get the exhibit out by saying fair and accurate over an illustrative exhibit also. What they're just doing is they're trying to up the offer into evidence by giving it the chance to get it out with the jury. So very often what you hear is a two-part magic word whenever you're dealing with an illustrative exhibit or a diagram that's going to be marked. And the two-part is, will this assist you in giving your testimony to the jury? And number two, is this a fair and accurate depiction of a chart of your calculation that you made in this case? Or is this a fair and accurate list of all of the factors that you took out into consideration? Now, if you're on your toes, you should say, if it's moved into evidence, you are objecting that it not be let go out with the jury, that it is merely illustrative if you're opposing the exhibit. But that combination is what you often hear in many courtrooms, is will it assist, and in addition, is it fair and accurate? Notice that when you have a written exhibit, it's no need for you to say fair and accurate. The fair and accurate piece of it is not something that is at issue in the case with an exhibit. that is a written document, like a BMI price list. All you need to do is you need to give a legal foundation for the document. You don't need to ask whether it is a fair and accurate condition from what it was in before. As long as there are no writings on it, that issue is not an issue for you with the writings. Now, what are the legal issues that you should be aware of whenever you're grabbing a piece of paper in the courtroom? There are fundamentally these, and you can think of them as OPRA if you need a mnemonic. The OPRA mnemonic tells you that you need to be concerned in a very few cases with original writings. And you should check the 1001 to 1008 section about original writings. You remember that basically what they provide is that when the contents of the original are an issue, in issues of forgery, when we are worried about what the condition of the document really looked like when it was first created, then in those situations where that issue is prominent before the court may be requiring an original as opposed to a copy. Now, if the person who is offering the document can account for the original, well, I sent it to the other side, so all I have is a copy. That will be sufficient, and the original writings problem will be taken care of. Now, privilege. Privilege is something that, again, doesn't often show itself, but if, in fact, the communication is between lawyer and client, there is one last place here for opposing counsel to object on attorney-client privilege. And certainly if the document has not been discussed in pretrial and out pops a letter from the client to the lawyer on the opposing side, the opposing counsel needs to be aware. Recognize privilege issues in accounting. Privilege issues with psychiatrists or medical doctors also can present themselves. And the privilege sections under 501 are the places that, remember, the federal rules says that the common law of privilege in the state courts will dictate what is privilege and what is not privilege. And so you should be aware of the privilege issues. Now, this relevance section, is the document relevant, is something to be concerned about. And let me just say a quick word about that. Relevance we often think of as 401 through 403. It could be that what's on the document is something that indicates a 403 problem. The document has information on it. You might describe it in some ways as the res gestae of the case, or they have minimal relevance because it explains something in the history, but it's overly prejudicial for its probative value. Take a look at some of the exhibits that you'll be examining for this weekend, and what you'll see is that there are some notes and telephone logs that have real questionable relevance, and certainly under 403 will be overly prejudicial for probative value. I want to also mention to you that under the 100 sections, what you should be aware of is there is the conditional relevance piece to be concerned about. Just because BMI has a price list doesn't mean that it was seen by Minicom and that they, in fact, understood that that was the way that they did business. This is especially true because, of course, Michael Lubell said, I tried to place the order. They didn't say it was a condition upon doing business. They did tell me to send up a follow-up in writing, but they didn't make it legally condition precedent. Well, how do you deal with that? Is that price list, in fact, notice that this is the condition upon which BMI does business, and there needs to be at least some showing under the 104 sections that, in fact, it was received, and that, in fact, this document then is relevant as putting Minicom on notice of the conditions upon which it does its business. So when you look at the conditional relevance sections, you realize this is just a question upon which a jury could conclude, and the threshold is quite low. And when you look at the documents in the materials, you'll see that the depositions indicate something about Lubell's having picked up the document, the price list, maybe as a source for the telephone number to call BMI. Is that enough? Well, we certainly could have a nice little argument about that. It seems to me that the better argument is that it will be something a jury could conclude that Lubell was then on notice, that he needed to look and send his orders in writing. Now, having said that then, your threshold step with every document is to say, do I have a relevance problem? And again, the main issue here is for your pretrial practice. Obviously, in the deposition, it is important for a litigator who has a view of what the trial is like to try to lay the evidentiary foundations that they can lay in the deposition so that, in fact, we won't be bogged down and bothered by it when we hit the trial. So you can imagine back in the deposition, it's important to say to Lubell and try to figure out psychologically how most likely you could get him to say that as the Vice President for Purchasing, he is under an obligation and a duty to read what's sent to him by potential buyers or sellers of products, and that he did that in this case, and that, of course, he would read the price list and understand the terms when he was picking it up. And if you could, in a sense, use that logic that either he was not doing his job or he did, in fact, do his job and read it, that, in fact, he is likely to admit that he did get the price list and did read it and did see these terms. Now here, under the A is authentication. Recognize that there are problems with documents about the signatures and whether the signatures are, in fact, authentic. Again, the 901 through 903 sections of authentication have taken care of a lot of the problems in this area that used to arise. What you have now is the ability to get self-authentication from the fact that you send notice to the other side that you're intending to use this document and that you're presuming that the signatures are right unless they tell you otherwise. And then it puts the obligation on them to contest the authentication of the signatures. And that is a tremendous tool that can really assist you and move you forward in being able to get the authentication in. If the other side says, no, that's not my signature, well then look in the 901 and 903 sections. You can do comparisons of signatures. The court can do it. The jury can be asked to compare the signatures. And typically then you do not have a signature problem in most commercial cases. Hearsay is the last step here. It's important to realize that when you're looking at a document, the document is often an out-of-court statement by somebody else. And the question is it being offered for the truth of the matter asserted? And when you're thinking about that, the overwhelming exception you're working at with commercial cases is the business records exception. In medical malpractice cases, the document may be a medical record, and so it could be a business record of a medical establishment, and the statements within it could also be exceptions under the exceptions to statements that are made for the purpose of medical diagnosis and treatment. Recognize that when you look at a document, there may be multiple layers of hearsay in the document. Business records cover multiple layers of that hearsay as long as the employees who are speaking to the document have duties to speak on behalf of the company in the creation of the record. But if there's somebody that's outside of that, you may have a hearsay within hearsay problem that arises even in a business record context. So you have to cover yourself on hearsay. Now, these issues that I've talked about in Oprah are things that, frankly, many of us just don't spend enough time in the courtroom to be able to see these things on the spot and on the fly. Let me tell you that, again, the way that to deal with these evidentiary issues is in your preparation when you're getting ready to move certain documents in and you're thinking about it the night before. Say, well, do I have an original writings problem here? Do I have a privilege issue? Is there a potential that I've got some relevance problem or authentication or hearsay? And that as you're preparing again your notebook on that document, that you should just account for Oprah as a way of bulletproofing that document and making sure that you're going to be able to get it into evidence. Okay? So finally then, let me just say a word. Well, let me go ahead and lay out the business records exception because it is so common. You'll need a memo, report, or record made at or near the time by or from information transmitted by a person with knowledge, kept in the course of a regularly conducted business activity, and a regular practice of the business to keep the record. And if you just list that out in your post-it, you're in good shape for your business records situation. Now, the persuasive use, finally, the last step of this, is something to be concerned about. When do you do this, and what does it show? When you take this exhibit out? Affects the story. Do you want the document to be the way that the story is told, or do you want the witness first to tell the story and have the document corroborate what the witness has just said? Is the telephone log the story of what it is that he did, or is the telephone log corroborate the fact that Michael Lubell, in fact, did request insurance? And so you're asking yourself, when do I show the document? And what does it show? Why do I want to show it? Why does the telephone log, for example, confirm the fact that Lubell probably asked for insurance on that day? And then what is the persuasive use of it? What do I need to say about it persuasively so the jury doesn't think that this is something that was cooked up or that is in fact created after the fact? Why would it be that in fact Lubell would keep a telephone log? And if you incorporate into your examination then of a person like Lubell what it is that he usually does in creations of telephone logs and why he does it and who checks it and why he checks it and why the business really relies on these kinds of things, you can enhance the persuasive foundation of the document that's being used. And if you can incorporate some of that in your planning, then the document can really sing for you. Finally, the last thing is how you display it. And there, again, I'm going to give you a little bit of a heads up for something we'll come back to later, and that is the persuasive use of a document is just not enough to have you say, see, members of the jury, here it is. The document, to make it helpful, is going to have to be large enough for the jury to be able to read it. And frankly, if what you can do is you can annotate it in some way or highlight it in some way to draw the juror's attentions. Please notify me immediately if the goods are in any way unsatisfactory or if there is any error appears in your statement. This is something that, in fact, remember that Virginia Young says when she sends the letter back to Mr. Lubell, and the argument is, as you remember in this case, that if in fact he had done that, we would not have had this problem and the insurance could have been ordered. So the use of the document is not just, well, there's the document, members of the jury, but that in fact you have a teaching obligation to call it out and to highlight it and to have it read so that the jury can understand the importance of what it is that you're doing. And that's where the creative use of the document is so important. Back to illustrative exhibits. This is the place where you want the witness on their feet, the police officer marking on the document. If you're demonstrating something or showing something, then what you want to do is to have that show, that enactment, and then have something in the record that will capture it in a way that allows it to be maintained. For the purposes of these kinds of annotations, if you want to keep that annotation, and if in fact that's something that the court allow for the jury to go ahead and do, you're going to have a preservation option for you. Frankly, that's what we'll talk about a little bit more when we talk about how you use visuals in electronic format to be able to make sure your record keeps what it is that is done to the exhibits by the witness for the purposes of illustrating the testimony. So, those are some tips for you about, if you remember, the technical foundation. I have in my hand document marked for identification as Exhibit 1, showing it to opposing counsel. May I approach? Handing you what's been marked for identification as Exhibit 1. Do you recognize it? Can you tell us generally what it is? Will this document assist you in giving your testimony, or is this a business record and the business record's requirements? I move Exhibit 1 into evidence. For the purposes of showing it to the jury, I'd like slide 15. That's the technical steps. You'll be drilled in that in your workshops so that everybody will have a chance to be able to get on their feet and do that. Your job, in addition, is to think about the legal foundations. What objections do I need to make when I'm opposing this exhibit? And what is it that I need to prepare for in terms of Oprah to get it in? And then finally, in addition, your preparation should include, how am I going to use it? Who's going to use it? What witness will I call? When will I show it to them? And that's part of your preparation for the use of an exhibit in a persuasive way. So thank you.